Assalamualaikum Doktor. My name is Wanuna Suhamiti Wan Azhar. My student ID 2022-782873.
Greetings and Assalamualaikum to my beloved lecturer, Associate Professor Dr. Tuku Intan Mainura. I am Patricia Liberty Mama Zain with students ID 2022-748653.
Assalamualaikum and good afternoon, Prof. My name is Amira Khadijah binti Kuriza and my student ID is 2022-736585.
Assalamualaikum warahmatullahi wabarakatuh to our lecturer, Associate Professor Tunku Intan Mainura, and our classmate. My name is Abdul Halim bin Zaidul Izam and my student ID is 2022-963-901. Precedent is defined as a judgment or decision of a court which is normally recorded in a law report. It is used as an authority for reaching the same decision in subsequent cases. In English law, judgments and decision can represent as follows: authoritative precedent, which is generally binding and must be followed; persuasive precedent, which need not be followed. Referring to the Oxford Dictionary of Law, authoritative precedent or ratio decidendi is defined as the principle or principles of law on which the court reach its decision. Under the doctrine of precedent, only the ratio of case is binding on inferior court. The ratio of the case has to be deducted from its facts, the reason the court gave reaching its decision, and decision itself. It is said to be the statement of law applied to material facts. These precedents are part of the judgment that represent that the legal reasoning of a case that is binding, but only if the legal reasoning is from superior court and from the same court in the earlier case. Number 1. According to the ratio decidendi of the Supreme Court, the case are binding upon the Court of Appeal and all lower courts and are normally followed by the Supreme Court itself. Number 2. The ratio decidendi of the Court of Appeal are binding on all lower courts and subject to some expectations on the Court of Appeal itself. Number 3. The ratio decidendi of the High Court is binding on inferior courts but not itself. Number 4. The ratio decidendi of inferior court usually does not create any binding precedent. Other than ratio decidendi, the remaining judgment is known as obiter dictum. Obiter dictum or persuasive precedent is something said by the judge while giving judgment that was not essential to the decision in the case. It does not form part of the ratio decidendi of the case. Therefore, it creates no binding precedent but may be cited as persuasive authority in later cases.
Next, I, Amira, will talk about the vertical operation. There are two ways the doctrine of precedent works, which is by vertically and horizontally. For vertically, it is about the superior courts, which binds all other courts to submit to them. An example, the magistrate court must follow the principles established by the High Court in a previous judgment. This is because when there is a similar situation that has arisen, they must follow the previous judgment and the decision that has been made by the High Court. When there is a similar situation and information about the issue that has occurred, this is going to be used. Court must decide the case before applying the principles laid down by the Supreme Court in 1987. The application of the doctrine can be found in the case of Mahkahyu and Public Prosecutor 1971 1 MLJ, where the judge stressed that the doctrine must be applied by the court to ensure finality in the law. Moreover, it is a situation in which a court is bound by the precedents of all courts in the same hierarchy. In general, the rulings of the federal court bind all other courts. The federal court's judgment binds the Court of Appeal, which in turn binds the two high courts and the subordinate courts. The ruling of the federal court and the Court of Appeal bind the high courts and their decision bind the lower courts. The decision that has been made by the higher court must be bound to be followed by other courts even though it is wrong or made per incurium. The meaning of per incurium is without taking into account any other relevant laws, decision or facts. The decision in Ramachandran and the Malaysian Industrial Court 1997 1 MLJ was incorrect and should not be implemented. The Court of Appeal, on the other hand, was not convinced. Indeed, even though it is flawed, this court is compelled to follow and implement the law as expressed by the majority and Ramachandran. It is the Supreme Court decision that sets binding precedents.
I, Nasuha, will present about horizontal operation, whereby some courts are bound by their own prior decisions, whether present or past. It is well known that horizontal operation is more complicated compared to vertical operation. First, Federal Court does not regard itself bound by decisions of the Supreme Court in civil matters. This can be shown in the case of Malaysian National Insurance and Lim Tiock. The Federal Court overruled the decision of the Supreme Court in the case of Tan Cik Ibrahim and Safety Life and General Insurance. It was held that Tan Cik case was wrongly decided and should not be followed to determine the case of Malaysian National Insurance. However, it was found to be different for the criminal matters, whereby the Federal Court held itself bound by decision of the Supreme Court. The proof is in the case of Tan Boon Kian versus Public Prosecutor, whereby the Federal Court unanimously held itself bound by the Supreme Court decision in the case of Hu Hee Chiang versus Public Prosecutor. In conclusion, the practice of the Federal Court in civil matters is the same as in criminal matters, that while treating previous decision as normally binding, the Federal Court will depart from a previous decision when it appears to do so. Next, Malaysian High Court Judge have acted on the assumption that High Court Judge is not bound by a decision made by another. For example, in the case of Ng Hoi Chu versus Public Prosecutor, it stated that Chang Min Tat did not follow the decision of Smith in the case of Wang Hang Fat versus Public Prosecutor. But it is different with Court of Appeal because this court is bound by its own decision. The proof can be seen in the case of Kesultanan Pahang and South Ox Realty, whereby Abdul Malik Ahmad Justice Court of Appeal stated that we are bound by our own decision.
Hi, my name is Patricia binti Mama Zain and I'll be presenting the three exceptions to the judicial precedents. Nevertheless, there are three exceptions where the judicial precedent may not be applicable. The first situation is in the case of its own previous decisions conflict. A court may opt to follow either one of the two conflicting decisions, though it ought not to refuse to follow a decision of superior court, otherwise it deemed to be overruled. Despite of whether it is the earlier or a later decision, the Court of Appeal may choose to follow one of the two decisions of the case that is more convincing. The later decision, however, is allowed because to the Court of Appeal, the dates do not matter. Second, the Court of Appeal is bound to refuse to follow a decision of its own, which, though not expressly overruled, it cannot stand with a later decision of the House of Lords. Third situation is where the Court of Appeal is bound not to follow its decision if it was per incuriam. A Latin legal maxim, per incuriam, gives a definition of true lack of care. It refers to a judgment of court which has been decided without reference to a statutory provisions or earlier judgment which would be relevant. The decision with a lack of care shall not have to be followed as precedent by a lower court. The circumstances of a precedent that is per incuriam is that the precedent is not binding as it was an action of the court that is based on ignorance and carelessness. This principle was adopted in the case of Young and Bristol Aeroplane Company Limited, 1945. In this case, the Court of Appeal may choose not to follow the earlier decision if it proclaimed that in the earlier decision, the principle of law has been misapplied. Furthermore, the Federal Court in Suralingam and Ramanathan Chettiar, 1967, held that one High Court judge does not bind another High Court judge. Lastly, in Joginder Singh against Public Prosecutor 1984, the High Court held that it was not bound to follow a decision of the High Court in Hassan bin Isaha against Public Prosecutor 1948 until 1949.